Hi, Brian Parker here with another exciting video. This one is quite unique, very unique. You know, I've done videos on appellate briefs. Appellate briefs, it's so boring I can't even speak. But this is another one of those, and I'm going to try and make it exciting for you in the context of if you don't believe in yourself and your cause, you can't expect others to believe in you. And sort of the opposite of that is if no one believes in you, should you stick to what you believe in because you believe it? All right? So in that context, I want to introduce you to a case that I have been litigating for quite a while on behalf of a good friend who has agreed to allow me to show you his name and his case. It's a thing that he feels strongly about, and so I'm going to introduce you to the case of Mr. Robert Baldwin's case against LabCorp. Big company, you better believe it. So our medical system is changing now, in that now we can just go to Walmart or Quest Lab or LabCorp and get a lot of tests we used to have to go to a doctor for. So, and it's a decentralizing of the system, yarn, but that's a good thing. So my client and friend, Mr. Baldwin, went and had a test done at LabCorp, paid for it, walked out and waited for the results. He started getting letters, calls saying, hey, you owe us money, you owe us money. I don't know how you walk into LabCorp and get some work done and walk out without setting something up. He paid cash. Everything was fine. He just waited for results. He got the results, but he started getting these calls saying, you owe us, you owe us. So finally, he started calling him back and saying, you got the wrong guy. It's, I paid, I did this. I talked to this person. You sent me the results. So clearly I did pay for this. Then they started sending him letters. Let me send you show you the first letter. Cindy, Shazam. And that said, immediate payment required. And it talked in terms of, let's emphasize that, Shazamski, failure to pay the past due amount will result in referral to the third-party collection agency and potentially affect your credit score. So now my client, and I just want to be transparent, we're on the same side. He's a consumer attorney also. We work together. And I think he and I both believe we don't want to be lawyers about stuff. You just want to do your thing, keep your head down. I protect my clients more than I protect myself. I put up a lot of crap before I finally have to be an attorney. But when it comes to my clients, I'm automatically attorney. It's just, I don't know why I'm made up like that, but my friend also is like that. He's not going to instantly sue someone. He just wants, hey, you've made a mistake here, and he tried to deal with it on the phone, and he finally had to send them a letter. And Cindy just put that letter up, Shazam, and he created what he called a cease and desist letter. He's in Florida. This case is in Florida, so he quoted the Florida collection practices statute here, which is quite a good one. Just on a side note, the FDCPA, the Fair Debt Collection Practices Act, is a nationwide federal act that has a one-year statute of limitations, and there's like 29 hard and fast ways that a debt collector can be regulated. It doesn't cover creditors. There is an exception to that. Creditors, if they pretend to be debt collectors in order to get a debt paid while remaining the puppet masters of the collection attempt, then the federal statute says, yes, creditors are regulated by the FDCPA, but there are state statutes in every state, or most of them, that do the same thing, that look to the federal statute and say, hey, we're going to mirror that. Florida does that and then some. Florida has a 2-year statute of limitations, whereas the FDCPA, Federal Act, only has a 1-year statute of limitations. And they include creditors. Creditors must follow the law of a state statute here in Florida that is oftentimes stronger than the FDCPA statute. Also, Florida allows punitive damages. So if the punishment is required to, meaning if the conduct meets certain limits or beyond those and is so bad, Florida allows, if you can prove it, punitive damages. And that can go, the federal statute set up, I think it's 2%. There's a percentage that you can go after someone for of their value. Similarly, in Florida, in order to punish, it must be worthwhile. If you punish someone $100 in a $1 billion corporation, it's not punitive. And again, you're not picking on them. Punitive means you've been so bad, we have to punish you so you don't think about doing that again, and perhaps others similarly situated. Remember, similarly situated. This is getting boring. Anyway, Mr. Baldwin sent his letter, and I believe he believed it was all over there. Look, he even said, I've made calls, and you've done this, and I have paid this. Please stop. So they did the right thing and left him alone. Oh, no, they didn't. They sent him the following letter. It just got worse. Shazam. And this one says, final notice, protect your credit. So clearly, sorry, my associate Lucky is making a lot of noise. So clearly, you're on notice. You've got some problems here. Your credit is being attacked. And it says in the letter, unless LabCorp receives full payment within 20 days, your account will be referred to an outside collection agency. We will authorize the agency to report any delinquent balance to the credit bureaus. So everything my client had done, and Buddy, had gone unheard. He'd sent a cease and desist letter, which they responded by upping the ante and make it even worse for him. So he, being the attorney that now has, basically LabCorp's saying to him, you got to go be an attorney if you want to resolve this, which is wrong. He shouldn't have to be like that, and he knew he was right. Cindy, put the emphasis up there for a second. Shazam. And again, it says, unless LabCorp receives full payment within 20 days. I don't know why they chose 20 days, but in Florida, when you sue somebody, you've got 20 days to answer the lawsuit. Maybe that's where that number came from. Most companies, as you know, from either a validation context or even under the federal FCRA, Fair Credit Reporting Act, incorporate a 30-day rule. So I don't know what this 20-day rule is. Maybe they're in a rush to credit report him and in a rush to kick him in the butt. It says, we will authorize the agency to report any delinquent balance to the credit bureaus. So he did they looked at the law, and very few people know this statute, the FCCPA in Florida. People meaning plaintiff's attorneys like myself and definitely corporations. And he found a statute, Florida Statute 559.72, parenthesis 3. Let's put it up there, Cindy. Shazam. And essentially, it says, in collecting consumer debts, no person shall. Whenever you see the word shall, that means there's no ambiguity. You will not do something, or you shall. You will do something. But there's no maybe, a suggestion. It's imperative. You must. So you must, when collecting a consumer debt, and this applies to creditors in Florida, tell a debtor who disputes a debt that he or she or any person employing him or her or him will disclose to another, orally or in writing, directly or indirectly, information affecting the debtor's reputation for creditworthiness without, Cindy, you've got the emphasis up there, without also informing the debtor that the existence of the dispute will also be disclosed as required by section 6. So you saw those two letters. Let's put the first letter up there, Cindy, Shazam. And if we can do it, the second letter, the more scarier with the 20-day letter, Shazam. And while they are telling Mr. Baldwin what they're going to do if he doesn't pay, they have not included something saying that the existence of the dispute, if he disputes it, and you saw his dispute letter, will also be disclosed as required by Section 6. So in a nutshell, if you threaten in Florida someone with reporting on their credit unless they pay, you must also give them the right to dispute, which is really common sense or embedded in most federal statutes. It's called a validation right to dispute, or under the FCRA, the Fair Credit Reporting Act allows you to dispute the debt. And by the way, quick tip, when you do dispute a debt, it oftentimes, sorry, I'm watching Lucky push this camera around. It oftentimes means they must stop reporting the credit as confirmed, and it mustn't be part of your FICO score. So disputes are strong and embedded with a due process context in federal statutes. And here, that's what it means. If you're gonna threaten the credit, and you should inform the person they have a right to dispute it and that it will travel along with any credit reporting. What if they're completely wrong? They're not allowed to just report it, even if they're completely wrong. You got a right to dispute or validate under the Federal Act. 6 that it refers to says, you can't disclose information concerning the existence of a debt known to be reasonably disputed by the debtor without disclosing that fact. So let me repeat that again. Let me put up just that sentence, Cindy. 6, Shazam. It's going to get weedsy, in the weeds, but hopefully this makes sense. If you're going to disclose information concerning the existence of a debt known to be reasonably disputed by the debtor, you must disclose that fact. So he wins, right? No. We filed this lawsuit. We amended the lawsuit, and we went before a judge under a motion to dismiss, and it became obvious to us that the court believed 3 did not stand on its own. We believe, and I think you'll see where this goes, that we have to, as a consumer in Florida, if it's being threatened, it has the right to dispute, and there must be a notice of the person threatening our credit saying, you got a right to dispute this. How they do this, so LabCorp said, no. Under 6, a separate section, subsection, we only have to send you a right to dispute if you've reasonably disputed. It's so convoluted. They're claiming that only disputes in their eyes subjectively that are reasonable travel along with the credit reporting. So we're saying you must supply the information in the letter where you're threatening someone they have a right to dispute. LabCorp defended saying, no. We don't have to put anything on the credit with the dispute unless we believe it is reasonable. Your dispute is reasonable. In other words, we first have to look at how you disputed. And we don't have to send you notice that you have a right to dispute. That's it. That's their position. So they filed a motion to dismiss. They went before the court. And remarkably, the court said, yeah, I kind of like this. You weren't too reasonable in doing such and such. Now, keep in mind, Mr. Baldwin has sent letters. He's called. He's actually paid the debt. And the judge is sort of hinting that we needed to allege the part of 6 in our lawsuit. So in our lawsuit, I'll put it attached to the website as part of this video. We're saying under 3, subsection 3, the other side, the debt collector, has to give you this notice, and that dispute must travel with the credit reporting. And LabCorp saying, only if that dispute is reasonable do we have to send it with the credit reporting. And that does not mean we have to send you that you have a right to dispute this. That is the position. So the judge kind of hinted she liked that position. We have no idea why. I do have an idea why. I'm not going to say it on the video. But she said, I'm going to dismiss this case, but I'll let you, Baldwin, allege 6 in a amended complaint if you amend it within 21 days. So my client and I are like, why? It doesn't belong. Even the legislature separated the two. It did refer to 6 in 3, subsection 3, but it's a standalone. And the judges said, no, it's not standalone. She hinted and kind of directed us, our lawsuit better say something about 6, because if it comes up in front of her again, she'll dismiss it with prejudice with no right to amend. So we did 2 things. We got creative. We kind of put 6 in the new amended complaint. There were 2 amendment complaints, but we did not focus on it. And what I did is I took their letter. Here is their first letter again, Shazam, okay? And you can see it's limited as to what they're obviously not giving notice to the client. They have a right to dispute. And I said to the court, hey, how about I write the letter for them? And I called it a safe harbor letter. And what I was saying to the court was, they should follow the law, but there's a bona fide error rule embedded in every statute, which says if they've taken measures and done standards to properly follow the law, their mistakes can't be held against them. On the federal level, legal mistakes are not covered under the safe harbor of the bona fide error rule. Bona fide error means, whoops, I screwed up, but I wasn't trying to do anything bad by it. So I was telling the court, there's a bona fide error rule embedded in the Florida statute, so how about you write this? And I rewrote the letter for them, Shazam for LabCorp, Shazam, and I essentially just added, you've got a right to dispute, if a credit report disclosure is made affecting your credit score before a dispute has been asserted and written notice is received from you that any part of the disputed and the dispute is reasonable, the person who made the original disclosure must reveal the request of you within 30 days, because that's the rule in most federal and state laws. Then I took the really bad letter where they said you got 20 days to fix it and pay, and we'll report the credit report. Let me put that up there, Cindy, Shazamski. That's the 20-day letter. And then I wrote my own letter, Shazam. And again, I incorporated the provision of 3 that protects my client and places them on notice of the right to dispute. So the court took a look at that and said, Parker, you're right, all is, oh, no, she didn't. I went on for hours. You can see my notes. I attached my notes to this video. I'll attach the actual transcript to this video of how long I spent showing the court what the law was. And she really didn't have a right to decide the case, because what is reasonable is a factual dispute. So the other side's claiming we're only going to report if their dispute is reasonable, and that doesn't mean we even have to give them the right to dispute. Anything that's reasonable is a matter of you say tomato, I say tomato. It's a factual issue. You got to provide why you believe it's reasonable, and we provide why it is not reasonable, or it's not reasonable enough. So a summary disposition motion, I'm just going to call it that, it's different names in different jurisdictions, attacks or looks at the legal aspect. And if you haven't met the law, case is out. Their reasonableness argument is a question of fact that doesn't belong in a legal analysis. So the court was convinced, I'm not doing that again. She just said, without really saying why 6 applies, I went deep on this for her, and she didn't listen. She just said, all right, thank you. I'm going to grant the motion to dismiss with prejudice for the failure to include the allegations pertaining to reasonableness. That's it. Nothing. You're supposed to go to bed at night going, well, that was a good decision. I do mind losing, but there are a few judges that are good, and you listen and go, you know what, he got it right, or she got it right. But you got an explanation. Even if you win, there should be an explanation for the other side to see if she was right or wrong, and you have how do you appeal that? Well, how you appeal it is, there's no explanation here. So we appealed. Now I want to tell you about belief and why. We knew we were right, but knowing you're right isn't always right. Because you've got to go through the filter. We all go through filters where they're choosing the best printer and fax capabilities. You know, there's always a filter. Well, the filter is the judge. You got to convince a judge, even if you're right, or if you're in front of a mediation panel or an arbitration panel, you've got to, being right isn't always going to be enough. And for some reason, this judge couldn't see our argument as really sound. If someone's going to hit your credit, they got to give you a right to dispute. I think that you don't need a law to tell you that. So we appealed, and the appeal court, I want to tell you something. Not only we filed an appeal, they filed a response, then they filed, I've never seen this, but this is what they did. At the appeal level, they filed a petition for fees from my client for $80,000. There's no justification for that. But they're a big corporation, and I think that told them, oh shoot, Baldwin may have something here, I think. And I think they knew the judge kind of didn't have grounds to rule as she did, and they wanted to scare my client. And who wouldn't be nervous? You're facing an $80,000 petition for and a lot of attorney fees and costs that you have to go fight this. So that's what he was facing. $80,000 out of his pocket for, I didn't see $80,000 worth of work. Anyway, I digress. So this was really bad for Mr. Baldwin. He knew he was right. He went all in. He didn't stop his appeal. We believed in each other. We're really tight, and we seem to connect on this statute and law generally. We work well together. So here's what when you file an appeal, it's because you really believe it. You're going to lose 9 times out of 10. I don't believe that, but that's essentially that's the math. They're going to give discretion to the lower court. You have to. The appeals is not going to allow every court to be reversed unless there's a real good reason that meets the standards under Florida law. So you forget after a while that you've gone through all this heartache and filed motions and appeals and have to meet deadlines. While you're waiting for the court to make its decision, you forget about the case. You got 15, 20, 30, 40, 100 other cases. And so I'm just sitting at my computer, and up pops this thing almost a year after we filed it. And it says, decision from the Court of Appeals, blah, blah, blah. I'm like, what is this? That's how much I've forgotten. I click on it, I go, oh. I mean, it all came into me. I'm like, so what you do as an attorney is you don't read the whole brief, the whole opinion that the court has made about your case. You go straight to the bottom and see whether, in this case an appeal, whether they're saying reversed or confirmed. And I just saw the big word reversed. It flooded through me because I knew we were right, and I knew Mr. Baldwin, my buddy, was facing all this pressure, and he may be on the hook for a lot of money, and it's a real problem. By the way, no case like this, has ever been filed. I get emotional about this. No case has ever been filed like this. There's no case in Florida state about this statute, this section of the statute. We knew we were right, but we didn't have the horses to support it. There was one federal case on the Section 3 that said, yeah, you kind of should do the right thing and give them notice, but it wasn't hard and fast. And the state court, which has no decision to go the way she did or basis, in our appeal, we said the whole issue, we went single issue here and just said the issue is about whether reasonableness is a factor in determining whether a creditor or debt collector is required to supply a right to dispute to a consumer that is also facing a threat to have their debts disclosed to third parties under Florida Statute 559.723. The appeals court specifically said, based on this language of subsection 3, Baldwin argues that the trial court dismissed his claim based on an erroneous interpretation of it. More specifically, the trial court determined that Section 3 did not require LabCorp to advise Baldwin of his statutory right to have his dispute communicated along with the reporting of the debt. Let's just put that up there, Cindy, Shazam. Unless LabCorp knew the debt was reasonably disputed, as contemplated by 6. As a result, Baldwin was required to allege that LabCorp knew he reasonably disputed the debt before he could state a cause of action under 3. Baldwin argues the court's interpretation of the section 559.723 was error. We agree. Oh God, that's so good. Based on the language, put this up, Cindy, Shazam. Based on the language of subsection 6, LabCorp argued below, as it argues here, that it had to know Baldwin's dispute was reasonable before it was required by Section 3 to notify Baldwin of any disclosure to a collection agency would be accompanied by disclosure of his dispute. LabCorp's argument fails. Accordingly, the trial court's order dismissing with prejudice Baldwin's second amended complaint is reversed. This case is remanded for further proceeding consistent with this opinion. Just put that section up, Cindy, Shazam. That is what I read when this appeal came down. That little sentence brought tears to my eyes. I knew what Rob, my buddy, was going through. I knew what I was going through. And he's believing in me, and we knew we were right for Florida consumers, that every corporation, every debt collector, every creditor in state of Florida should be sending that notice, and I don't know of any that do. Think about it. Our case is a class action against LabCorp. That's why they came hard at us, hard and fast, and several dismissals. We filed discovery saying, how many letters of these did you send out? They moved to have that stopped too, and the judge said, sure, let's wait on that until you've heard my decision. I don't think she wanted a state class action in front of her, because I can't see a justified reason for seeing something that the appeals court clearly saw. It's in the statute is what they was basically saying. So now, every corporation, every creditor, every debt collector is facing a new tomorrow, a new burden. That the law it's been there ever since, that basically most debt collectors focus on the federal act and they ignore state collection act because they're usually toothless. This one isn't, and now it's a new day. We have the first case in this state that says, you gotta supply somebody with notice if you're gonna attack their credit. Seems reasonable, right? Well, they were claiming again that it has to be reasonable, meaning LabCorp, the way LabCorp sees reasonableness. So that's a whole plate wrong, but I hope this wasn't too boring. I will put on this video on my membership website several Word templates, my complaint, my amended complaint, my appeal brief, the actual transcript of the court saying we got no case, the actual opinion of the appeals court saying, yeah, you do have a case in trial court, this is going back to you. So I get to stand in front of the judge and be a very mature adult and not bring up the fact that she was wrong and we were, if you will, right. You don't say anything, but boy, 20 years ago, I don't know what I would have said in this situation. I'm just so relieved for my buddy Rob, and I hope you get something out of this. It's big, it's huge in the state of Florida. You just gotta believe in yourself. You gotta believe in your case, you gotta believe in your client, but if you are the client, believe in yourself. Real quickly, when I was a young attorney, I had this great case. I had all these violations by this defendant. It was in federal court. I was already scared of federal court. I was a young attorney, but I hung in there and I got all the way to trial. I'm trying to court a case in federal court, and the judge, every time we went back to his court, he goes, hey Parker, why don't you knock this off? The jury's not gonna know 8 violations and this. And each time he got me down to like 3 violations, jury comes back and says, sorry, Parker, you lose. Had I had those 9 violations and not listened to outside pressures, I know I would have won, all right? But You listen to people to your own detriment. Believe in yourself. Believe in your case. Never give up. It's easy. If you are right and you know you're right and you've done the homework, believe in yourself. Who else is going to believe in you other than me? I hope this helped you. Good luck.